Hello, my name is Andika Saputra. My student ID number is 1951139 and I'm from University of International Batam. And today I'm going to discuss about what is private international law, the history, the principle of private international law, and the example of the case. Without further ado, so let's jump to the discussion. Private international law consists of principles and rules for dealing with legal disputes that have a warrant element. For example, a cross-border divorce case or transnational commercial dispute. The scope of private international law varies from country to country, however, and each jurisdiction has its own rules. In addition to the rules made by national authorities, treaties, model laws, and other instruments have been brought in by international organizations to regulate the area of transnational disputes. These organizations include the Hague Conference on Private International Law, the International Institute for the Unification of Private Law, or UNIDROIT, and the European Union. The history of private international law, namely during the Roman Empire, the historical development was marked by the birth of the 12 tables in the middle of the 5th century. These 12 tables were laws made by the Roman elite. It formed the basis of the Roman constitution and Roman civil law. It provided the legal basis for granting patricians, elite families, more privileges than the plebeians, who we might call the middle class, had among the Roman citizens. As Rome succeeded in conquering other areas outside Rome, the Roman Empire was formed, which consisted of Roman citizens and non-Roman citizens. The Roman attempted to codify applicable laws in the form of codex. The last and most famous codification is the Corpus Juris Civilis, which was compiled in the era of Emperor Justinianus, and hence is also known as Justinian Corpus Juris or Codex Justinianus. And as the time went, the wider area of the Roman Empire caused many problems, among others because of the many riots and chaos in the 3rd century. To observe this, the Roman carried out government reforms by dividing the empire into the Western Roman Empire and the Western Roman Empire. This division of empire, in fact, weakened the Roman position against the German and the barbarians. The German invasion finally succeeded in destroying the Western Roman Empire and taking over its territory at the end of the 5th century. The Eastern Roman Empire only ended 1,000 years later with conquest of its capital Constantinople by the Turks in 1453. The end of the Western Roman Empire is generally agreed upon by historians as the early entry of the West into the Middle Ages, which ended up to the 12th century. Throughout today, the Roman-Greek tradition of art and literature and law is buried, or it could be abandoned. Given a long span of time, approximately 700 years, it is not surprising that Roman law and the Codex Justinianus were neglected and then forgotten. In the period spanning the 6th to 10th centuries, which is also known as the Barbarian Age, private international law has not been studied as a separate system, but the awareness of positive legal pluralism that applies to the people remains, and entered during Renaissance. The Renaissance is a time when people in Western Europe returned to classical literature and then developed new literature and arts. Modern science is starting to develop. At this time, we can find the basic of the modern private international law system that originally developed in Italy starting in the 11th century. The revival of Roman law occurred in the 11th century and continued until the 13th century, with the start of investigation about Roman law. The development of private international law is based on the fact that there is a coexistence of various legal systems in the world that are equal. Every lawmaker in country basically forms laws according to the needs or situation in their country. However, sometimes there are legal events that show a link or relevance to more than one legal system of countries. Now, we about to enter the principle of private international law, a principle that form the basis for the formation of private international rules are: 1. The principle of nationality. The principle that applies a person's national law in determining one's personal status. 2. Domicile principle. The principle that applies, the law of domicile of a person which applies in determining a person's personal status. 3. The principle of freedom of contract is a general principle provided by law in making a contract, which is contained in Article 1338 of the Civil Code. 4. Lex Fori principle, the principle that enforces the law of the judge in a private international law incident. 5. The lex loci contractus principle, the principle which follows the law where the contract is made in agreement. 6. Lex loci solutionis principle, the principle that follows the laws where the agreement is executed. 7. The proper law of contract is the law that applies in a contract is the state law that has the most linking points. 8. The most characteristic connection is the law that applies in contract is the law of the party that has the most characteristic personality. Now we're entering the case of private international law. A husband and wife who are Russian citizens and married in Russia. Then they moved to France and they bought a house in France. They obtained French citizenship. And then husband and wife is on vacation to Singapore. While they're on vacation, there was an accident. A Singapore citizen hit the husband with a car, and then the husband died in the accident. While the husband is still alive, the husband bought land in France. Then the wife demands 1/4 part for the production of the land. The case is filed in the French court. Characteristics: l'expatrié, France, because they obtained French citizenship. Lex loci celebrationis, Russia, because they're married in Russia. Lex domicile, France, because they have a property in France. Lexitus, France, because the wife filed in the French court. Lex loci damni, Singapore, because the accident happened in Singapore. That's an explanation on private international law and discussing what private international law is, its history, the principle of private international law, and the example of the case. And that is the end of my presentation, and thank you for watching.